production, and the requirement, A, you have to have so much on hand, and B, then we're asking then these cultivation facilities that, based on 15,000 square feet, may be producing quite a bit that then is destined to be destroyed. So is there thought in your mind how that's going to operate in terms of having this 50 pounds always available for immediate sale?
So I think the or language will be key, and so A should be relatively easy to meet the 15-pound requirement within the harvest within 120 days. I do see your concern, and that is a number that we're still kind of looking at and considering. So please mark, let's mark that.
Okay. Yeah, we're in the transfer of ownership area or locations, page 1415. Don't see any interest there. Now we're kind of coming into the more operational component, the quality assurance programs. General comments around either ops or QA. So I'll pose a question at this point, particularly around the quality assurance plan. Are there guidelines spelled out in the rules around how to get people ready to maintain and sustain a quality assurance program, or is that to be determined by the cultivators themselves?
A little bit of both. So we will have minimum standards within the application instructions with more detail around the quality assurance plan and what we would like to see. But then it'll be up to the applicant to demonstrate their expertise, their proficiency in the area, and then up to the panel that we assemble to evaluate that and make sure it would comply.
Other questions or comments there? Moving through onto page 18, where we're talking about packaging and labeling. At least at the cultivator level, I think this processes and dispensers will have other rules around that, but questions specifically here at this level. Okay, I'll pose one. In letter A, in A and B, you have a pathway for cultivator to dispensary, and then cultivator through processor to dispensary. Can you articulate for me what pathway you think would come under A, and when would that come into play, bypass the processing stage?
I got you. So what we were looking at is a way for, with the plant materials that will be cultivated at the cultivator facility, essentially what the processors are doing is just repackaging it, or even just sending it right along. In instances where they're repackaging, it could expose it to potential contaminants. There could be other issues there. And so what we're looking at doing with this A-B distinction is find a way to account for and allowing cultivators to ship properly packaged and labeled plant material directly to the dispensary.
Okay. How about waste disposal? Any questions in that area? Something I hadn't considered, to be perfectly honest with you. Another quandary. Yes, Becky?
Just based on your slides, you mentioned that to dispose, a level 1 employee would have to do this, and it would have to be recorded on camera. I was just wondering if there are any other second employee sign-off requirements or things like we would tend to do with opioids in a hospital, or those types of requirements.
We looked at this, and one of the reasons we have the one type 1 employee is just because of the level of interest they have in the facility and more committed to doing the right thing, making sure everything is in compliance. It would be good to look at maybe having a second employee, if that wouldn't be too much of a burden, and getting some feedback on that. But I think combining the fact that we would even have the ability to direct access those cameras and view the disposal might help with that. And so that's something that we looked at and we took pretty serious from a security standpoint. But certainly we could look into. I know there are, I believe it was Illinois did have 2 states that do it, other states only have 1. So we could continue to look at that as we come up with the final draft.
I think the thought process behind my concern with that is if you're dealing with plant material, it might be easy to divert a small amount and not necessarily notice that on camera.
Yeah, I see your concern.
Okay. Yes.
I'll take you back just to the labeling issue. I noticed on H.
I'm sorry,
BH. It's the laboratory analysis.
Okay.
One of the things that patients certainly gotten used to when they go through the grocery stores, they see the percent, daily percent required, to be healthy, effective, whatever that we're classifying that. Will there be something like that you foresee that, you're going to have the ingredient list and you're going to see this is designed for these purposes, or this particular blend is appropriate for these disorders, diseases? I mean, is that in the works? Is it something you're considering?
I think that will be more for dispensary rules, and that's why we're going to work so closely with there. And I think that's why I like how we're set up in Ohio, and we're able to work so closely together. But that goes more towards the dispensary label. So I think it's just making sure that we're working together. So if the cultivator does go that route, whatever they have on their label meets the dispensary standards, the information the patient needs.
Great.
Okay, other thoughts in that area? Ed?
I do have a quick
Yes.
question to go back to quality assurance. It talks about being in compliance with water quality and pesticides and chemigation, fertigation, and it must be registered with the ODA. Are those going to be inspections done by the ODA or USDA or a third party? Are they going to be annual, or are they just going to be spot checks? How's that going to be done?
So great question. So the initial inspection before they can operate, we have some language that gives the department the ability to kind of tap into that expertise and have people that can review that plan, make sure that they did everything they say they could from a pesticide, fertilizer, fungicide usage. And then the language currently would have a list through the department, so we would know what chemicals are being applied. So unless they were doing something illegally, which would put them out of compliance and put their license at stake, those are the controls that we would have in place for that.
Okay. Moving into inventory control and storage. Anything that came to your mind in that particular area? Okay. Security. We have quite a bit of rules around security here. Anything here that you'd like to give some feedback on or have questions?
I'm curious, how dangerous has it been for these other states? How big a problem is security been?
So in the states that have similar rules that we've proposed here, the diversion and security hasn't been a huge risk up until this point. Talking with Connecticut and Illinois are two that come to mind. They have not seen any diversion and have the ability to monitor it appropriately, speaking with the regulators. So I think it's always a concern, but to the extent that we have some of these abilities to use the video recording device to see what's going on there, to allow for silent alarms that can notify law enforcement, which I'm sure the cultivators will appreciate. I think both parties are kind of protected from risk and from any security issues.
Other questions? I'll pose one here. I think I heard in your presentation, Justin, about cultivators having to give access to the state to their video feeds. Is that live access, tap right in, or is that retrospective review existing video recording?
That would be live. So what we've seen in other states is these vendors are able to provide a link, click on the link, and see through the cameras that are installed throughout the facility.
Okay, and that would be residing in Commerce to tap in and that, or who would want to do that kind of work?
Commerce. So it'd be the enforcement. Yeah, it would be the enforcement end. And if dispensaries had a similar rule within the dispensary rules, they could have the ability to do that too.
Okay. Anything else there? We continue to move through.
On inventory,
Yes, go ahead.
is there, say for a level 1 cultivator, is there a maximum that they're allowed to have on inventory? So if they have, I'm certain that this crop's going to be like anything else. There are going to be different varieties that are going to store better. Once they're packaged, they're going to be able to stockpile it. Is there going to be a maximum amount that a cultivator is going to be able to stockpile in order to keep him from having oversupply or having the price down for other cultivators?
Currently in the proposed rule, there is not, but that's a great point, and I'll jot that down and take a look at that. I think it is important to consider, and something we'll look at the language for.
We've overlapped a couple of topics here, and I'm just curious, from the standpoint of the cultivator and the processor, a lot of them are going to be dealing with a lot of waste, especially the cultivator, the installation of the product. Is there any thought being given of the possibility that in the future they could be processed, stored, frozen for quite a long time? There wouldn't be waste, in theory, right? You could push it to that point. Is that being considered, or is that, okay, it is?
Yeah, as in the definition section, we have an expiration defined 1 year from the date it is harvested
Okay.
for plant material, and 1 year from the date it is processed for any of the medical marijuana products. So that is taken into account there in the definition.
Is it possible, though, to store it for much longer?
Well, if they stored it for much longer, it would be deemed expired.
Okay.
And could not be sold.
But I mean, you could conceivably, for having it stored for quite a long time.
Yeah.
You'd never have peaks and valleys of supply. There would be a lot less waste.
Is there something you propose looking at as far as adding language, or?
That would be the idea. I mean,
Yeah.
typically, I store, pieces of human brain for years and years, and it's adequate for further analysis. The things in there are still stable. The same thing could be said for the molecules in the plant. This is just sort of standard. Why can't we apply that to the products once they're extracted? They can be stored, especially the tinctures and so forth. But the plant itself being frozen for years at -80 centigrade. We do that regularly with, hospitals, pharmacies. Is that an option?
So you're advocating to extend the expiration period?
That would be the idea. In other words, to avoid, because it would reduce waste and prevent peaks and valleys of supply.
The question I have for you, though, would be a lot of those pharmaceuticals in the hospital, I mean, there's always an expiration date on that.
But if you could prove it was still stable,
Right.
which would be easy enough to do, just
You could likely do that with a lot of pharmaceuticals, but it's
could.
not typically done. I think that'd be a deviation of.
That's a good point. But this product is so different in how you never think about cultivating your storage of Prozac. It just shows up and it has an expiration date. This is a plant product, and we're discussing discard of waste. We don't do that with other drugs. So should we approach it differently?
Well, my personal opinion, is that I don't think I support not having an expiration date on a pharmaceutical use.
Sorry, I wouldn't say that. Could it be extended? Yeah. Is there an intermediate?
I think it certainly can be discussed. I would need to, I guess, understand a little bit more. One question I have with this just being proposed is, from a testing standpoint, would there need to be additional standards or other testing methods with a product that has been frozen for a year? I don't know that at this point, but I think there's a lot of considerations.
Yes, right.
But certainly something we can, look into as we, tweak these rules and come up with a final rule.
Right. How far can we push it for the benefits that might arise? Yeah.
Well, I'll just, from a chemistry standpoint, I'll just comment that we have struggled in this space with not only medical marijuana, but others because of the lack of research. And that is directly related to the lack of research materials, physical plant materials. I do know that although the DEA has reaffirmed its stance that marijuana will remain a class 1 with no medical purpose officially, they did also relax the guidelines on production of research medical marijuana. So perhaps in subsequent years, as more people get their hand on it, study it more, and we can have more evidence around how to extend that, we do have an opportunity, I think, in that space, given the DEA has been kind of a controlling point to that to date.
Right, from a chemist standpoint, we'd like to break apart the plant and pull out the individual molecules that we think that have them in the balance we want, ideally. At that point, we could mix and match like any pharmacist might attempt to do to give the patient the balance of compounds they need. That allows us to store it for a very long time.
It does.
Right. But we need to know those.
In those instances where we do have active ingredients identified, we have made pharmaceutical versions of it, a Marinol for one, where we know the stability of that and it can go on for a period of time. There's just a number of compounds here we just don't know enough about yet. I think we will as time goes on.
And then we can inform the law. Yeah.
Yep. Okay, there was just a little bit, I'm sorry, go ahead.
Sorry, Justin, this is a question pertaining to section 07 about the uninterrupted supply.
Yep.
Did you have a timeline on when they were going to have the requirement for that inventory? Because the licenses are going to be available in May, correct? Mm-hmm. But physicians' rules and regulations won't be available for recommendation until September. And the concern is there may be a challenge with adoption and applications by physicians. Mm-hmm. And I'm just worried about matching that supply and demand.
Yep, and you hit the nail right on the head. There are a lot of factors to consider. There is language in here that if something like that did arise, they could petition the director and there's a way to get around that unlimited supply requirement. The goal of that language is to prevent what we've seen in other states like Nevada, where people just want to get the license and put one plant in the ground and hold on to that license until hopefully if recreational comes or something else that would incentivize them having them grow. We're focused on a consistent quality supply of medical marijuana. And so the way that we viewed it is the best way to do that is to make sure the individuals with these licenses are utilizing them and growing a quality, consistent product. So it's a valid concern, and I think we have language with the waiver or the petition in there to address those situations, but we can absolutely look at that language and make sure that's accounted for.
Okay, we'll continue moving through. We're on page 24 now, looking at the rules around laboratory testing. Anything that goes in your mind as we got to that section? Moving through to the prohibited activities for cultivators. Anything there that we want to weigh in on? 2-08 is about records and reporting requirements. I think a lot of that is straightforward, and I think we'll probably get directly on that from the public as people look at what they're going to be asked to do. Moving on to the next big section, which is the inspection piece, page 26.